Hi, I'm Paul Melnick. I'm with the law firm of Altmiller, Melnick, Demers, Steele, and Rosati, PLC. Our office is located in Tysons Corner, Virginia. And today I'm going to be talking to you about the types of deeds that are typically prepared by attorneys when trusts are utilized, revocable living trust as a part of an estate plan. But first, I'd like to give you some background about myself and my journey as an attorney, the different firms that I've been at, different experiences I've had, and I think you'll see that just about any practice area could lead into a real estate practice. So I started law practice in 1990, and in law school I had a particular interest with criminal law, and after my second year I had interned with the U.S. Attorney's Office in Alexandria, Virginia. I took all kinds of criminal law classes, and I was interviewing for a prosecutor job to start after I passed the Virginia bar. And around that time, my father, John Melnick, had a falling out with his partner. And he said, "Paul, hey, would you like to join the firm?" And it sounded like a great opportunity. So suddenly I went from wanting to be a prosecutor to a criminal defense attorney. And my father had a wide range of practice areas. It was a general practice. I mean, he did everything except bankruptcy and divorce. So I jumped right in. I was doing everything from personal injury work and trials to criminal cases, criminal appointed work. I was doing, just everything under the sun pretty much, except the two practice areas I mentioned. And it was great experience. And around 2005, I began honing it down and concentrating on estate planning, estate and trust administration, and real estate. And real estate seemed to permeate what I was doing. It permeates all the areas, and really all of them are complementary. So by 2010, I was just doing the three areas basically: real estate, estate planning, and estate and trust administration. So that's where I am today, and I'm extremely happy with the areas of practice. And around 2005, I became involved with the Virginia State Bar Real Property section. And it was some of the best people I've ever met. And I'd been in a lot of groups, and they're benevolent. They'll do anything to help you. They have forms, they have advice. So it's just a great group of people in the real estate bar. So I couldn't be happier with where I've landed now after so many years of practice since 1990. So today I would like to talk about, as I was saying, deeds into trust and transfer on death deeds to trust. So the other deeds that could be prepared, one of them is a gift deed, but the practitioner needs to be especially wary of gift deeds with estate planning. The danger is in the domestic relations context, where a gift deed, where one spouse gifts to another, could inadvertently cause separate property to become marital property. And then that could be a time bomb for later, and then one of the spouses will end up being disadvantaged, and guess who they'll come back against? The attorney. So be very, very wary of gift deeds. They have their place, but I think in estate planning, there's other deeds that are tax exempt that fill the role just as well. And the other one is a quitclaim deed, and that you should be very wary of quitclaim deeds too. They raise red flags for title insurers. They effectively say, I'm not saying I own the property, but anything I own I'm conveying, and there's no warranty. So that's another one to be very, very wary of and use very infrequently, only when it's necessary. So the first deed I'd like to go over is the deed to trust. When I'm doing estate planning for clients and they want a trust program as a part of their estate planning package, in addition to the other typical documents, what I'll do is propose to them whether they want a deed to trust or a transfer on death deed to a trust. And over the years, the benefits of the deed to trust, there's not really hardly any benefits over the transfer on death deed. The deed to trust, the benefit of it is once the property's in the trust, then it's likely that no other deeds are going to be needed until distribution. The drawbacks are things like the name of the trustees and the name of the trust will have to be on all documents in the future if they deed the property, if they rent it. This could cause issues if real estate agents, put them as individuals and then nobody realizes that's wrong. They need to change the insured on their homeowner's policy. They need to get an endorsement on their owner's title policy, which could be a real pain if their policy is decades old. If the property's a rental, they have to get lender consent, or else there might be a due on sale clause in their deed of trust. If the property is refinanced in the future, lenders oftentimes want them to take the property out of trust and put it back in, which could cause delay and cost. And the other is if there's something like a refinance, there could be review fees and trust certification requirements, and that could cause attorney fees and other costs. So the other choice is the transfer on death deed to a trust. And so this is, it's a statutory structure that was enacted in 2013, and it's a total of 18 sections, but it's an easy read, it's easy to understand and straightforward. And so with the transfer on death deed, the statutory, the sections in the Act actually have a sample transfer on death deed. When it's to a trust as a designated beneficiary, there is, you would need to add the trust powers and the specific trust language that would kick in if the property actually transfers at the transferor's death. And so it's a very special deed that only isn't, it takes force only on the death of the transferor, the person that executes it. So the benefits are, it's pretty much, the benefits are really the opposite of the detriments of the transfer into the trust. So with the transfer on death deed, it's revocable. The title stays in the individual names. That's simplicity for future transactions because the people only appear individually. It's a great option for rental property because the due on sale is not triggered because the transfer on death deed is effectively invisible until the death of the transferor. And it's also, it also makes refinancing easier because, like I said, it's invisible to anyone's eyes until the death of the transferor. So there's no problem about it needing to be transferred in and out of the trust during a refinance. Government benefits of the transferor or designated beneficiary not affected because it hasn't actually been transferred during the lifetimes of those people. Creditors of the designated beneficiary cannot attach it. There's no need to change the insured on the homeowner's policies, and same with owner's title insurance policies. That can just stay the way it is. And there's also no need to deliver, and that's a technical term for a deed. It's the last thing that has to happen for effectiveness and validity. But it doesn't, the transfer on death deed does not need to be delivered, and no notice needs to be given. So in a sense, the designated beneficiary might be named and not even know about it until somebody tells them after the death of the transferor when the transfer on death deed becomes effective. But the drawbacks of the transfer on death deed is when there's joint owners with survivorship as transferors, they all have to join in the transfer on death deed as well as any revocation document. So that everybody has to get together and do the same thing for the deed and the revocation to be effective. The the description in the designated beneficiary should be as simple and straightforward as possible, just because we're talking about the title to real estate. The more complex it is, the more chance there's going to be a problem with the title later, trying to prove who owns the title. A deed of confirmation may need to be filed on the land records to show who's the actual owner after the death of the transferor. And there's no built-in incapacity planning for the transferor. And if they're holding the property individually during their lives, something like a power of attorney will need to be executed also to take care of any possible incapacity and for the management of the property. If a power of attorney isn't there, then there might need to be a court-appointed conservator to manage the property for the transferor during their life until the property can transfer pursuant to the transfer on death deed. And if there are joint owners with survivorship who execute a transfer on death deed, it's possible that one or more joint owners may die, and then the other joint owners with survivorship, they can revoke the transfer on death deed, they can change its provisions, they can do another one, and that may go against what the deceased joint owner wanted. So along the way, with the joint owners with survivorship, it can be changed or revoked until the death of the final surviving joint tenant with survivorship. So the other technicality with transfer on death deeds is they must be recorded prior to the death of the transferor. So a transferor can't just sign it and just let it sit somewhere and not be recorded until after death. And the reason for that is certainty of title is built in to the Transfer on Death Act in Virginia. And that's how it's different in large measure from a will, because it has to be recorded prior to death to be effective, and any revocation must be acknowledged prior to the transfer on death deed that it's revoking, and that also must be recorded prior to the death. So the idea is that everything having to do with the transfer on death is recorded prior to the death of the transferor, and that's just for certainty about what's happening. And along those lines, a transfer on death deed can't be destroyed by like tearing it up or shredding it, similar to the way a will can, and that's also certainty, that the revocation has to be done according to the statute, and it has to be recorded. And that's just so that everybody knows what happened. So as you can see, with the large amount of benefits of transfer on death deeds, I'm a huge fan of them, and they are a very important tool in the estate planner's toolbox, and they fit beautifully in many plans, whether there's a trust or whether there isn't, whether the client is just looking for a will substitute. So I'm glad I got to share my background and a little bit about the transfer on death deeds to trust and deeds into trust. I hope this has been helpful. Thanks for joining me.